Catherine Amirfar.
And I'm Cal Raustiala.
And this is International Law Behind the Headlines, coming to you from
the American Society of International Law.
Hello, everyone. Welcome to another episode of International Law Behind the Headlines. It's my pleasure today to welcome on the podcast Chimene Keitner. Chimene, who has appeared here before and is a good friend of the Society, active in many ways, is the Alfred and Hannah Fromm Professor of International Law at what's still UC Hastings. We were just chatting about the interesting story of the UC Hastings Law School and its name debate. But for the moment, still Hastings. And Chimene has a lot of experience as well inside the Beltway, State Department, lawyer, and so forth. And so I thought she was the perfect person to bring on to talk about one of the really interesting issues flowing through the federal court system right now, involving Saudi Arabia and specifically Mohammed bin Salman, better known as MBS. And I think we'll probably refer to him during the podcast as MBS, and the lawsuits that are pending against him for the murder of Jamal Khashoggi. So we're going to talk about those issues with Chimene. Chimene, welcome to the podcast.
It's always great to talk to you, Cal.
Yeah, great to have you. And so I gave the briefest of summaries about our topic, but I really want to let you say a little bit about what's happening in the courts right now with Judge Bates, and sort of what are the interesting questions that are arising, because there are many, and we're not going to be able to dig into everything, but there's so many interesting issues here. So give us a little overview.
There are so many issues, and I think it's important to preface all of our conversation, of course, with the fact that we're dealing with an extremely brazen, brutal, and really tragic killing that has been documented, confirmed, as folks might recall, in a fairly unusual move. The Office of the Director of National Intelligence, ODNI, declassified their assessment in February 2021 that MBS had approved a capture or kill operation involving Jamal Khashoggi, who is, of course, a Saudi national, but had been living for a number of years in Washington, D.C., reporting for the Washington Post, living outside of the country precisely because of continued threats against him, had been separated from his wife and children there, and had recently in an Islamic ceremony married another woman who, in order to marry her civilly, he required a certificate from Saudi Arabia attesting to his eligibility to be married. And it's his quest for that certificate that ultimately provided the occasion for this fairly elaborate ruse to be constructed that led ultimately to his death. But all of those underlying facts are fairly well documented, and so this is a really interesting but tragic case that we're going to be talking about today.
Yeah, I agree completely. And in fact, I think as many listeners know, President Biden was just in Saudi, and after repeatedly on the campaign trail, making clear that he would treat MBS or Saudi generally as a kind of pariah, seemed to walk that back significantly. And there was a whole issue about would he shake hands, and instead they kind of fist bumped. And
I'm not sure. It's like the COVID fist bump. How does that fit in the diplomatic register of interstate relations? I'm not sure.
Yeah.
But in terms of the timeline, so this murder took place in October 2018. As folks will remember, back then it was first a disappearance, but it became evident fairly soon that a murder had taken place. This complaint was filed by, again, some refer to her as Khashoggi's fiancée. The complaint refers to her very understandably as his widow, and also the human rights group of which he had recently been made executive director, whose acronym is DAWN, D-A-W-N. And so those two plaintiffs filed this complaint in October of 2020 in the district court in D.C. And as you mentioned earlier, it's been assigned to Judge Bates. And it is a complaint with federal claims under the Alien Tort Statute and the Torture Victim Protection Act, again, all relating to essentially the orchestration of this killing. Of course, there's no allegation that MBS was a direct participant, but there are various allegations in the complaint, both about his approval of this operation, but also his apparently or allegedly instructing the ambassador to the United States from Saudi Arabia, who was his brother, to reassure Khashoggi that going to seek this certificate in the Saudi consulate in Istanbul would be safe, because Khashoggi understandably was very concerned and had actually tried to obtain the document from the embassy in DC in the first instance. So this whole conspiracy is alleged to violate both of those provisions. Also, there are pendant state law, common law tort claims in this complaint. And although when it was filed, one might have assumed that the head of state immunity question would be ripe for discussion immediately, as folks know, with U.S. litigation, there was, a fair bit of motion practice, motions to dismiss filed ultimately both by MBS and by some of his co-defendants. And so it's really just on July 1st of this year, actually, that Judge Gates issued an invitation for the U.S. government to offer views if it sees fit. And so that the government has not made any submissions or filings in this case to date.
Yes. And my understanding is, or at least this is based on reporting that I've seen, that the Biden White House is also asking for an extension, in part because these issues are fairly complex and it sounds like there's some internal debate. Is that your understanding? Is that?
Well, absolutely. I mean, I have no idea what's going on internally, but I will say it would be highly unusual for the government to be able to turn around an intervention in a case like this within 30 days in any event. And so the request, I think the initial invitation was to submit something within a month. The government asked for a 60-day extension. So the deadline is now October 3rd. And then what just happened yesterday, we're recording now on the 21st of July. So what happened on the 20th is the parties agreed that they should postpone a hearing that had been scheduled for August 31st. That's going to be postponed now to November 2nd to be able to take account of anything that the government decides to submit. And I think the one thing to bear in mind is that, and this is, again, fairly standard, the government may end up submitting something that says, we have nothing relevant to say here. And so, that in and of itself would be noteworthy, but we will see some sort of submission that ranges anything from we have nothing to say to addressing any one of the four issues, actually, that the judge identified as perhaps warranting some comment or anything else that the government decides it wishes to bring to the court's attention.
Great. So let's start with the issue, if you agree, of head of state immunity, because it seems to me in many ways it's obviously a central issue. It's also one that Biden's visit that we just referenced really highlights the power of MBS and the fact that he is effectively, by nearly all accounts, the person who is most powerful, most significant, making the decisions that matter the most. And it's no surprise that when Biden decided to make this trip, despite his earlier claims and promises, this is the person that he met with. But nonetheless, he's not the head of state. So flesh out a little bit what the issues are and whether there are any relevant precedents.
This is fairly sui generis, at least in recent practice. So the kind of immunity that you're talking about, of course, is a status-based immunity that attaches to any sitting head of state recognized as such by the U.S. government. And so it's both customary international law immunity, but also one that, although not codified in any U.S. statute, is well recognized in U.S. courts. And so if we look to the sort of definition of head of state immunity in the International Court of Justice's famous arrest warrant case, in which listeners will recall there was an arrest warrant for the foreign minister of Congo, and the ICJ ultimately decided that in issuing that arrest warrant or requesting an international arrest warrant, Belgium had violated the status-based immunity of Belgium's foreign minister. And so the ICJ in that decision held that certain holders, and I'm quoting here, certain holders of high-ranking office in a state, such as head of state, head of government, and minister for foreign affairs, are entitled to this absolute status-based immunity while they're in office. Now, Cal, of course, your question arises because, as you said, it seems that MBS is performing many of the functions we would associate with a head of state or a head of government, but in his list of titles, of which there are many, none of those three, head of state, head of government, or minister for foreign affairs, appears. And so part of what's at issue here is, do we take a sort of formalistic approach to head of state immunity, or is there an argument, which certainly MBS makes in his motion to dismiss, that the scope of head of state of immunity needs to encompass more people than maybe a formalistic approach would suggest?
Great. And it's implicit in what you just said, but in the roughly 2 decades since the arrest warrant case, the ICJ has not really elaborated on that clause or the such as language that seems to imply that perhaps those 3 categories or titles are not the only 3. It
right? Hasn't. And we can certainly read into the rationale for head of state immunity and talk about that a little bit in terms of thinking through, which other officials might come within the scope. MBS's motion to dismiss talks about sort of 2 possible ways of squeezing him in to this category. One is, of course, by virtue, as we've just discussed, of the roles that he actually does play. They've also dug up some jurisprudence on the protections afforded to a head of state's members of a head of state's household. And this is, of course, analogous to the protections afforded members of a diplomat's household. Traditionally, the context in which protections for the household arise is when you have dependents. And so the idea is, your dependents should not be targeted for the same reasons that you yourself are not targeted. The opposition to the motion to dismiss points out that he is certainly not a dependent of his father anymore, and so that kind of derivative head of state immunity should not be available to him. But these are the kinds of arguments Judge Bates is going to have to parse.
Yeah, let's dig into that a little bit, because it does seem if the rationale for head of state immunity is in some ways grounded, I guess there's an open question. To what degree is it grounded in sort of status or dignitary dimensions of sovereignty, and to what degree is it grounded in a kind of functional rationale, one that we often see articulated with regard to a wide variety of immunities, that but for some form of immunity, international affairs couldn't really take place, and it would be inhibiting of many kinds of interactions that we would generally want to see. If it is functionally grounded in some important way, and the family members suggest that, the addition of family members do suggest that, is it crazy for him to be claiming that? It doesn't seem crazy. I'm hesitant to be supporting his position, but it doesn't seem crazy.
I've got to admit, Cal, initially it seemed a real stretch to me. And actually, Bill Dodge and I have an article that came out very recently in the Fordham Law Review that really provides an exhaustive examination of foreign official immunity in U.S. courts. And we mention the bin Salman filing and talk about the fact that he is not a head of state, and so as such, nor a head of government, nor a foreign minister as such, would not be entitled to immunity under any of those categories. But I do think that if Judge Bates were inclined, or if the U.S. government were inclined to dig into those rationales as opposed to applying a formalistic rule, I would agree with your characterization of the argument as not crazy. I'm not sure I'd go farther than that, but I would agree with the not crazy characterization.
Well, again, I'm not, you are much more steeped in this, and this is why I'm asking you questions and not the other way around. But it does seem, just looking back at the broad kind of history of foreign relations, even in this country, let alone around the world, it seems like there's been a proliferation of positions. Let's think of the National Security Advisor, for example, someone who wouldn't fall under any of these categories articulated by the ICJ, but is an extremely significant figure. And at times in American history has been much more significant than the Secretary of State ever is. I'm thinking of, let's say, Henry Kissinger during the Nixon years. Much more significant player who routinely froze out the Secretary of State out of all kinds of things. So it does seem a bit formalistic to fixate on these titles rather than the actual functions. On the other hand, of course, if it's simply a functional inquiry, it gets very messy, very fast, very fact dependent. And I can't imagine the ICJ, for one, ever sort of endorsing a wholly searching inquiry of this type that I'm describing. But it wouldn't be beyond a federal court to do that. So I guess one question is, do you have anything more to say on that? And then two, what are your predictions about what the Biden administration will actually do?
Wow, that's a lot. So let's all really excellent observations. So I'd say number one, taking a step back, the Judge Bates's job is to apply the customary, the common law, and here's the, that was a Freudian slip, the common law of foreign official immunity as it has evolved in the United States. That's the body of law that the Supreme Court told us in Samantar versus Yusuf applies to these determinations. There are some ongoing debates about the extent to which a judge in his position would have to defer to an executive branch determination of immunity. Mm-hmm. Interestingly, to the extent that any executive branch suggestion of immunity for MBS is based on a recognition by the U.S. government that he is a head of state, a head of government, or a foreign minister, that would be, that's understood to be binding. To the extent that the government, if it did, started to wander into these sort of functional arguments, I would argue that's not binding, because there's no greater authority, in my view, again, others disagree, for the executive branch to be elucidating the principles of common law that apply to official immunity determinations. There's no greater authority in the executive branch than there is in the courts. In fact, perhaps to the contrary. So one question is, what body of law do you apply, and how much weight do you put on the executive branch's submission? And the second question is, well, of course, common law is heavily informed by customary international law. Bill and I argue in our article that U.S. courts should not go beyond what customary international law requires. And certainly I would argue that customary international law does not require granting immunity to MBS, precisely because he is not one of an office holder of the stature that's required. And number two, precisely because of the line drawing problems that your question illustrated. There are line drawing problems with the sort of household concept if you go beyond minor dependents, and there are certainly line drawing problems if somebody's supposed to figure out, whether Kissinger is, really calling the shots or not, in sort of looking at a foreign country. Now, status-based immunity, to the extent that it has this functional purpose, does not begin and end with head of state immunity and, of course, as is codified both in treaty and in statute, diplomatic immunity for ambassadors. There's special mission immunity. And so if the argument is that somebody like Kissinger had to travel to a foreign country while he was national security advisor and didn't want to be sued while he was there, or more importantly, arrested and prosecuted while he was there, there is a recognition that individuals who conduct special diplomatic missions as recognized by the receiving state can enjoy a temporary status-based immunity while they're performing that function. So that doesn't help MBS here, of course, because he's already been served by mail. He does have some personal jurisdiction arguments that he's certainly raised. But in terms of listeners who are concerned that, sort of it's either head of state or the troika, as we call it, or nothing, rest assured that, again, to preserve the ability to travel, there is, the United States is not party to the Convention on Special Missions Immunity, but it certainly has, in a couple of filings, recognized that U.S. courts can, again, at the direction of the executive branch or suggestion of the executive branch grant special mission immunity in appropriate cases, but that kind of protection is important on the functional level. It doesn't get us past the fact that lawsuits like this are both extraordinarily important for vindicating important interests and values that the plaintiffs are seeking to vindicate, but at the same time can create tremendous foreign relations problems.
Yeah, absolutely. I mean, it does seem, I guess, two reactions. One, to go back to where you began with the question of what's binding on the court, or the degree to which the executive branch's determinations are binding. Just to clarify that flows from the administrations, from a constitutional power to receive ambassadors and recognize and so forth. So the courts are not in a position to say, no, this isn't the foreign minister. But I totally agree with you that once you get out of that troika, it's a much more open texture. It does seem like the existence of special mission immunity does provide an opening for MBS's lawyers to say, look, we're not, whatever the ICJ may have said in that arrest warrant case 2 decades ago, they left that a bit open because they were clear it's not only these three. They could have said only these three, they didn't. And then in addition, we have this, of course, many other forms of immunity, diplomatic, consular, et cetera. But we also have this very specific idea of special mission immunity that suggests something that is really quite functional. So that does seem to at least open the gates to it. But as we talked about, it's quite slippery and not necessarily useful for him here, except in a kind of, perhaps you could assimilate to it. You can't actually rely on it.
Yeah, I think it would be tricky in the sense that, you don't carry your special mission immunity with you at all times, right? It's right. Very time bound. And so it means that certainly were he to come here for some sort of an official visit, he couldn't be served with process during that visit. But again, this suit is already well underway. And so it's in an age in which physical travel is no longer necessary to the conduct of diplomacy. You could either argue that these sort of traditional notions of protecting, diplomats while they're traveling and so forth are antiquated. You could also argue that the immunities are less needed precisely because you can conduct diplomacy from afar.
I think that's a really interesting point. I think you're absolutely right about that. So let's talk about, I want to make sure we don't run out of time to talk about some of the other dimensions of this case. I think at one point, it may have been in our kind of pre-conversation, we talked about the notion of conduct-based immunity. Of course, there's an active state question. You mentioned the Alien Tort Statute. So I'll sort of kick it to you, but what are the other issues that you think listeners would be interested to hear about?
Sure. Well, I guess the first thing is just to let people know we've talked about the deadlines. So what's happening in the government right now? As John Bellinger, former State Department legal advisor, has said, and I think in various ACIL meetings, including a panel I chaired at an annual meeting on immunity, the State Department process is what the State Department now does with respect to requests for suggestions of foreign official immunity. This is what they got out of the business of doing for foreign state immunity when the FSIA, the Foreign Sovereign Immunities Act, was enacted in 1976, but they're still doing it for requests for suggestions relating to foreign officials. And again, here, this request came from the judge. It was an invitation. They could just decline the invitation, but what they're going to try to figure out are precisely what we're talking about. And I think, again, the really easy thing would just be to say, we confirm he is not a head of state or head of government, and then send the question back to Judge Bates to figure out the rest. Of course, Saudi Arabia is going to want much more than that in a governmental response. They'd want a much more fulsome response. The active state defense that bin Salman has raised, and I guess the other asterisk here, especially for Civ Pro aficionados who may be listening, is Bill and I argue, and I think make a very good case in our article, that immunities are an affirmative defense. So just think of that in terms of the posture of these defenses that have been raised in the motion to dismiss. Active state doctrine, really post the Kirkpatrick case, is a very narrow doctrine. John Harrison from Virginia has some really interesting work on active state doctrine, and I did some work previously. So it's surprising to me, not surprising, it's interesting to me to see it rearing its head again in this context. So the gist of the argument, and I think for purposes of time we'll have to leave it there, but just to let listeners mull over it, is that if part of MBS's critical role, as alleged, is having told his brother to reassure Khashoggi that traveling to the Saudi consulate in Istanbul would be safe, that sort of official communication was an act of state that shouldn't be adjudicated in a U.S. court. And again, I think that is really stretching the act of state doctrine beyond its current role in U.S. jurisprudence. There's some other D.C. cases that I think also have started to stretch the act of state doctrine too far. And so that's something to watch in this area. The more interesting relevant. Yes.
Sorry, can I just ask you to clarify that? So when you say it's stretching, is it because it's a kind of simple communication? Is it that nature of it? What? Just say more.
I stretching because really what the act of state doctrine has become is simply a rule of decision telling U.S. judges that they need to treat as valid official acts taken within an official's own territory, right? So if MBS, directed the transfer of certain assets within Saudi Arabia to somebody, that would need to be taken at face value, not second guessed by a U.S. judge. Right. So the, sort of stretching it to kind of this idea of anything a foreign country does is beyond the purview of U.S. courts to comment on is I think. That's what I meant by stretching. It's really, John Harrison uses the word sort of validity. It's a rule of validity. We need to treat as valid those official acts, within the country's own territory.
And does it matter if the relevant act in question plausibly or apparently relates to a crime? In other words, is there a question here at all about whether an official act can encompass something like this alleged act?
So Bill also has a great blog post of the different meanings of official act. And so in the act of state context, it really wouldn't matter as long as it was lawful under the domestic law of the country in which it took place. But again, it's the whole parallel kind of set of inquiries. And as you might recall, this doctrine was really articulated in the case of sort of foreign bribery cases and things like that. It has, however, and this is what I've traced in my work, its doctrinal origin in this Underhill versus Hernandez case that people often cite is very much linked to that of this other category of immunity we haven't talked about yet, which is conduct-based immunity. And the reason we haven't talked about it is that MBS does not assert it as a defense. And so as an affirmative defense, he has thereby waived the ability to assert conduct-based immunity. It would be odd for him to raise it insofar as there have been prosecutions in Saudi Arabia of individuals involved in this attack. So it's obviously a criminal act, criminal conspiracy, even though he denies involvement. But also, it makes the State Department's job a little bit easier in the sense that kind of threading the needle of what kind of conduct should be treated as an official act for conduct-based immunity purposes is, sort of an ongoing debate. And again, here, I think, if allegations are true, ordering or at least approving, the killing and dismembering of a journalist certainly would not fall within, I think, any plausible concept of official acts or official functions. But there is an extreme argument out there that anything done under color of official authority, with apparent authority, even if not actual authority, even if it amounts to violation of domestic law, international law, nonetheless should be shielded by conduct-based immunity. And so I think we will not be testing that extreme argument in this case, but in other foreseeable cases, that is still a lingering issue.
Yeah, and that basic question has obviously arisen in many other disputes in many other contexts. Well, this has been great. I think we've covered a lot, and I really appreciate your insights. Not only because you've obviously written and thought about these issues for quite a while, but you've also worked on them directly. So I hope as this case moves forward, and it appears like it will this fall, we may have occasion to bring you back on to talk about it further.
Always glad to talk about immunity, Cal.
Great. Thanks, Chimene. Thanks for coming on.